Hello, welcome everybody. This is part of a new series that our Denton's United States Region Employment and Labor Group is doing of some short video chats to talk on some topics of current interest. This particular program is going to focus on what's new with non-competes and other restrictive covenants. I am Dan Beale. I'm an employment lawyer in our Atlanta office, and I'm joined by Joe Allen Whitney. Joe is a partner with our Des Moines, Iowa office. And so we're just going to have a brief conversation about new and recent developments in the world of non-competes, and we're not going to cover every last detail everywhere, but we're going to hit some of the highlights so that you'll be a little more informed about what's going on. So, Joe, let's just start with some basics of what is a non-compete? What are we talking about here, just to make sure everybody's on the same page?
So traditionally, when we're talking about a non-compete, we're talking about some form of contractual agreement where an employee agrees not to go to your competitor. Basically, I'm not going to take data. I'm not going to go to your competitor. I'm not going to compete with you for a certain period of time. Lots of states have different laws relating to how those are enforced or what they're done. But in general, until relatively recently, they were enforceable in most places. So really, it's a way to help manage your workforce, manage retention, but also protect your data privacy and your trade secrets.
So historically, non-competes have been primarily governed by state law, and there's a variation from state to state. And many people know that California, for a long time, has largely prohibited non-competes in the employment context. But as you said, in most other states, they've been enforceable within limits. But earlier this year, I believe the Federal Trade Commission has taken a swipe at non-competes, has begun to take a swipe at non-competes. Can you give some clarity as to what the FTC has done and what it means?
Sure. What you call a swipe, I would call a bulldozer through the middle of non-competes, because I think it's pretty big. So you actually have to go back to July of 2021, where we get an executive order from the Biden administration called Promoting Competition in the American Economy. It directs the agencies to look at non-competes. And then the people who take the ball and run with it are the FTC, right? And so the FTC then proposes in January of 2023 these very broad non-compete rules, which would literally outlaw non-competes of all types in every industry, with a very limited exception of such as when you're selling a business. You own 20% or more of the business and you're selling it. And so they propound, right, this very broad, sweeping sort of rule that would apply to every state. Now, they did put that out for comment, right? All federal regulations have to go up for federal comment. They extended that comment period. The last time I looked, they had seen almost 27,000 comments. There's a difference 23, 27, but it's a lot, right? So almost 27,000 comments. So they have pushed back action on that rule. And my most recent understanding is until April of 2024. And that they are anticipating meeting a number of times and continuing to get through those comments to see what they can do. The proposed rule is really, really broad with almost no exceptions. And I think that's probably what they're going to be looking at.
Yeah, I think the conventional wisdom seems to be that they will probably put some more exceptions in for maybe for highly compensated employees, or maybe for certain kinds of restrictions. But yes, we'll be waiting till April to find out what they actually end up doing. Okay, so that's the Federal Trade Commission. There's another federal agency out there, the National Labor Relations Board, which has tried to make its own headlines in non-compete world. So what has the NLRB done?
Well, so there's some history about that. In February of this year, you get the McLaren-McComb decision, which really looks for it at sort of confidentiality issues. Then in March of this year, General Counsel for the NLRB does a memo that talks some about that, but also calls into question at that time the non-competes, right? Not just confidentiality, but the non-competes. And then in May of 2023, you get another memo from the NLRB that basically says non-competes violate Section 7, that they prohibit people from organizing, that they prohibit them from going to other employers. They impact upon their ability to get a job. And so the NLRB, more or less, says that non-competes are not going to be valid. Some limited exceptions, but they don't define the exceptions. It's very difficult to tell from what we have there, what is okay, what isn't okay. And the thing that the NLRB is also doing is they're talking about those things being retroactive, right? So that would reach back sort of through time. And so that creates other issues for us. Sort of, if I have this thing in place now, is it still good? Will it be good in April? Will it be good 3 days from now, right? That creates a lot of uncertainty for our employers and our companies.
So is this NLRB ruling going to, or position that they're taking, is this going to impact, say, non-competes in executive agreements?
So I think the way it's read right now, it would. Will it eventually do that? I can't tell. Okay. To me, right, as a lawyer who practices in this area, it feels a bit like an overreach. It feels very broad. It's a memo. It's not a regulation or rule. Remember the FTC, they're going through the full process, right? They're creating a regulation. They're taking comments. The NLRB didn't do any of that. And so that to me feels like a little bit of an overreach. And we've certainly seen a lot of litigation in agency overreach, right, over the last 10 years or so. And so I would anticipate that that would see litigation about whether it's enforceable in executive, or sales of companies or that kind of stuff. So I think it's a little tough to tell where the NLRB stuff will land.
I do think it's likely that it will be held to only impact employees who are actually covered by the National Labor Relations Act, which would not be supervisory employees.
Right. And I agree with you. I mean, that's completely the position that I take, is that it would not cover supervisory employees. But when you read them, the only thing I would say is that when you read the memo, she talks about, Jennifer Abruzzo, who wrote them, talks about how, well, this could impact how a supervisory employee interacts with a non-supervisory employee. I feel like it's very, very broad.
Right.
And that's the part that makes it so hard for companies, right? Because the way they're treating is it could apply, you're not unionized, it's a upper level executive employee, does it apply or doesn't it apply? And I think my local NLRB case representative and I are likely to disagree on whether it applies or doesn't apply. And so that's the thing we're trying to think about.
Okay, so the bottom line of the NLRB is that that position is currently in effect. We're not waiting on anything. They have taken the position. These are a violation of federal labor law, and the contours and reach of this is still quite a bit vague. Right.
And the other thing that I would just add to that is the FTC has signed sort of cooperation agreements, MOUs, memorandums of understanding with the National Labor Relations Board and also with the Department of Labor, at least in part to look at these issues of non-competes and how non-competes impact upon workers and workers' rights. And so you're going to continue to see a lot more interagency cooperation on that. And so it'll be interesting to see how the FTC regulations sort of play together in the same sandbox with the NLRB, right? So it's going to be interesting to see how that's going to work out too. Or terrifying. Right. It could be interesting or terrifying, either way.
So that's the federal agency landscape. What about our highly functional Congress? What are they doing?
So are we talking about local Congress or the national Congress, right? So what we did see, so they've had a bill that's come up various times, died, and been reinstituted. So in February, they reintroduced what's called the Workforce Mobility Act of 2023. It looks like one they've had before. It looks very much like the FTC regs, but it hasn't gone anywhere, right? It hasn't moved through anything, but it does look a lot like what the FTC was proposing. And so you are going to get some of that sort of synergy or snowball effect where it starts to push some of that stuff through, I think.
Okay, so there's a possibility of a federal statute, but no real indication right now that that's going to come into effect. All right, so now let's talk about state law. as we said, historically, the states are where non-competes have been regulated on the theory that they are restraints on trade, and historically state courts have been fairly skeptical of restraints on trade unless they're narrow. But there's been a lot of action in various states around the country. We're not going to hit all of them, but let's talk about a few of the more recent developments. Can we talk about New York? What's been happening in New York?
So New York is complicated, right? So New York passed what I would consider to be an exceptionally comprehensive ban on non-competes, right? Very comprehensive, much more than you might see in other states. But to the best of my knowledge, it hasn't been signed by the governor yet. There's been a lot of pushback from Wall Street. There's a lot of concerns. There's a lot of statistical analysis about how that impacts financial markets, how that impacts traders, the kind of thing, because New York has an enormous hub of industry and a variety. And so it's hard to sort of judge how it impacts all of that. So it's a very broad ban. It's pretty comprehensive. My understanding is it doesn't exempt out highly compensated, that you don't have that same issue, but that it's not enacted yet because you're getting so much pushback.
Right. And I think if it is enacted, it would only apply prospectively. It would not reach back to existing agreements.
No, which is why, Dan, when it comes to New York law, I would defer to you. But yes, it does apply prospectively, not retroactively. In fact, the only one that's really clear about being retroactive, I think, right now is the NLRB.
All right. Now let's talk about Minnesota.
Right. Minnesota is new. Okay, so Minnesota is very new, July of 2023. So it just came up this legislative session. It's pretty much all non-competes with both employees and independent contractors. Okay, so Minnesota also looks at the independent contractor issue, and we have that. It doesn't have an exception for highly compensated employees. It doesn't prohibit the sort of sale of business kinds of things that we would see. That's also reflected in that FTC rule. When you're selling and you own a substantial portion of the business, we can still have those ones. And a lot of those are directed at, goodwill, preserving goodwill, brand name recognition, that kind of stuff. So it's pretty comprehensive, and it sort of fits together with a lot of other very employee-friendly statutes. And so you'll see a lot really attached to that.
Okay, and so I think, correct me if I'm wrong, but I believe Minnesota then joins California, Oklahoma, and North Dakota as being the 4 states now where, from a state law perspective, non-competes are largely illegal in the employment context.
Yeah, I think you're right, Dan. I think across the board, California, Oklahoma, North Dakota, and Minnesota are just flat out bans. Okay. And with California, being the precursor, right? I mean, that's the first law. So they're gonna draw a lot from how things like that got enforced in California, I think, too, when you look at newer bans.
Well, speaking of California, there actually, I believe, are a couple of recent laws relating to the existing law that have further enhanced the prohibition. So we can go into that in detail or not. Probably not. I think the high level of that is simply that they've made even stronger prohibitions to make very clear that those prohibitions are to be read broadly and with really no exceptions with regard to employees.
Right.
So let's talk about another jurisdiction, not a state, but the District of Columbia, that has some significant, not complete ban, but significant limitations.
So it started broader, right? Then they sort of narrowed it down a little bit because they had some business backlash, that kind of thing. Again, DC, like New York, is a hub for an enormously wide array of industries, that kind of thing. There's some procedural rules about it. And Dan, I may have to defer to you on the highly compensated part, because I think in the highly compensated, there are some specialty rules that relate to that.
Yes, I believe for the highly compensated employees, there are some rules that, so is largely a complete ban for employees that are not in the highly compensated category, and highly compensated is currently, for this law, $150,000 a year in compensation, or for medical professionals, $250,000. If you're in the highly compensated rule range, then you can have a non-compete, but only if it's pretty narrowly drafted with some specific rules and can be a maximum of 1 year. And there's also some procedural rules that you have to give the employee a copy of the non-compete at least 14 days before employment begins, or 14 days before they have to sign it if they're already employed. And you have to give them some disclosures, like here's a notice about describing your protections under this non-compete statute, and some other disclosures like that. So there's a lot of technical rules that if you're going to have a non-compete in DC, you've got to make sure you follow all of those procedural rules.
One of the things that I think is really interesting about the DC statute, right, is that some of it is industry specific, right? When you talk about medical professionals, and that's one of the things you see in some of the other states who haven't banned them. Like here in Iowa, this last legislative session, they banned non-competes for mental health professionals. That's it. Just mental health professionals, because we have underserved populations. We don't have enough mental health professionals, but that then opens the door for bigger changes. And I think you see that in other states too. Sometimes it can be industry specific, or the rules are true for one thing, but not for a different kind of industry. So that's added complexity for that.
Yes. All right. So then I think without going into great detail on other specific states, I think we can say there's a trend of a variety of states that have put restrictions on non-competes for lower wage workers. Right. I believe Illinois and Colorado and Maryland and Massachusetts, in addition to DC, all have limitations or restrictions on the use of non-competes. Yes. With lower wage workers, and I think that's a trend that may continue as well. Since I am here in Atlanta, I'll mention just a couple of Georgia-specific things that not as dramatic, but within the world of Georgia non-competes. We have a statute that was enacted about 12 years ago that broadened the enforceability of non-competes, but the courts have interpreted it a little more narrowly than we initially expected, and it has actually become a little harder to enforce various kinds of restrictive covenants. The Georgia Supreme Court has recently said, if your agreement, even if your agreement says you should use the law of a different state, if you're litigating in a Georgia court, you need to use Georgia law. And so that can be another restraint on the enforcement of covenants. And then a very specific thing, under Georgia law, the courts have recently held that you can't have a covenant that prohibits the recruiting of employees unless you limit that geographically. You must have a specific geographic limitation on that. I'm not sure the logic of that case actually makes sense if you read it, but it is what it is for now. So Joe, can you provide any sort of final takeaways or thoughts for our clients that are struggling with navigating this crazy world of non-competes that we're in?
So, I think what every lawyer, I mean, I know what you would tell me, which is know how many non-competes you have and who you're using them for, right? Because you're always going to be better off when you can really articulate a good business case as to why I have this non-compete, right? And know what state you have them in, coordinate so you understand what that state law is. But one of the things that I tell all of my clients is we need to start thinking really carefully about trade secrets, about knowing when information should be confidential, about enforcing confidentiality, about how we let people take our data out of our company to remote areas, because when non-competes get harder and harder to enforce, what you're going to have to protect is your data, right? You have to protect your information, your data, what you have. You have to use those things, which are covered by the Trade Secrets Acts or covered by other confidentiality rules, to try to get you to something like the same place. And so that's where I'm focusing right now, is knowing where they are, knowing what states they're in, but also getting people to really understand the trade secrets and the data confidentiality parts, because I think those are going to help us out.
Great. Thank you very much for your time, Joe. Thanks for everybody for listening, and we'll be back soon with another installment of our employment and labor chats on different topics of interest to our clients. Thanks, Joe.
Thank you.